Hey guys, it's Kathy. I hope you guys are doing well. Oh my gosh, the pictures of your animals in chat is awesome. I can't get any more animals. I can't. I have too many. But man, you make me want to go get some more. Oh, Buffy. So I got bad news. I have no tasing tonight, unfortunately. It is with a heavy heart that I tell you that, just so you know. But believe it or not, it just doesn't happen often in court. You would think it happens more often, but it doesn't. There's that one clip. They had the taser on the guy before he even came out to the courtroom, and it was supposed to keep him in line during the court session. I can't remember where it was, but it was this guy got tased. I don't know how many times. It was like on his ankles or something because he just still wouldn't behave. But I do have, the next best thing. How about a contempt of court? We could start with a contempt of court. Um, and this time, not unlike yesterday, I'll leave the volume on. It won't be muted because I'm a professional. Here we go.
Do you have a cell phone with you?
What do you mean, do I have a cell phone with me? Everybody has a cell phone with them.
All right. And did you record
I
court
just said, no,
on
I
your
didn't
cell
record
phone?
anything today. And I know why you're in here, and I just clarified it. And it's right here. I've got the recording right here. I'd love to play
That
it.
is not a cell phone. That is an iPad.
Right. I didn't record anything on my cell phone here today at all.
Go ahead and play the item that you'd like to play for the court.
Sure. Okay. Thank you. So they did an illegal assessment. Adrian over there. So this is the weekend that I came in on a Friday to file.
Deputies, can I have one of you come forward, please, if you would kindly do a service for the court? Mr. Oberlander, could you open your photos and videos and I want to make sure that there is no video or photos of the court proceeding?
I'm going to open all my stuff up. I mean, that's ridiculous. You told me I could play my one thing here. I clarified one reason.
And I just want to verify you didn't record court. If you don't want to, we will begin the contempt proceeding now.
Why would you hold me in contempt? I'm not playing any audio in here at all for the court today. I came in here to protect my son, and I clearly stated to him.
Court has continually expressed to Mr. Oberlander that he has been disruptive in the courtroom. The court has given him an opportunity, even though he has been in direct contempt, the court has given him opportunity to establish that he hasn't further committed contempt by recording the court. Instead of cooperating, he is choosing not to cooperate and show that he is not.
What are you doing? Why are you putting things on record that aren't happening?
Are you showing him your photos?
Right here, yeah.
Pull up his recordings, Your Honor.
Yeah, it's right here.
Tuesday.
And I'd like to see photos and
No, I'm not
videos.
Dude, that I'm not.
Okay.
I've been saying right there. Why do you have the right to invade all my stuff because you want to? There's no proof. There's no.
Mr. Oberlander, you have continually been disrupting the courtroom, and a report was made to the court that there might be a video or audio recording. I've given you an opportunity to let us know.
The camera's in here to see that I haven't video or audio recorded anything. You can look at all the evidence.
Given that this has been so disruptive and so extreme, the court at this time is going to hold you in direct contempt.
Your Honor.
The court has given you an opportunity to present any mitigation, and the court is going to take you into custody.
Your Honor, can I at least play the recording that you said
no,
I could
thank
play?
You. I heard enough of it to know that that was not a recording of the court.
It's not a recording of the court. You said I could play the recording that I wanted to play.
You wanted to know that you weren't recording anything else. The court at this time will have you back.
I just showed them that I wasn't.
Tomorrow morning at 8:30 in the morning. We will have you back. We will appoint counsel to represent you for the contempt proceeding in the morning.
Your Honor, I'm sorry. I just showed them. Listen, I haven't had any.
Please do not further disrupt court. Move to the side. You're going into custody.
Why am I going into custody?
I've already made a record. Please go to the right.
How long am I didn't hear any of that, Your Honor.
I'll see you tomorrow morning at 8:30 in the morning.
Your Honor, I can't, last
To
time
the
I've
right.
been there, I didn't get any of the medical treatment I needed.
Mr.
I didn't get
Oberlander, do not make this go till next week.
guys, what?
Thank
Why are
you.
you guys taking all my stuff?
Stuff down.
Hey,
We will grab. Keep walking, Mr. Oberlander.
Your Honor, last time they did this, my US.
Mr. Oberlander.
I had broken evidence last time this was done to me.
Mr. Oberlander,
It wasn't documented correctly and it was broken.
continuing to interrupt my
You guys see
courtroom.
what's going on here? I came here to defend my son that's being abused for mental ill that's not being properly cared for. Now I'm going to jail.
I hope you will
Right. What
cooperate.
did I even do besides try to offer a recording to help protect my son? Did I do anything other than that?
He's got his back here, about 2 rows from the back.
Thank you, deputies. Ms. Lowry, my hope is that Ethan is able to work with Summit Stone despite the disruptions that are caused by his father. It's my understanding his mother has been very helpful for him. If there's anything else the court needs to do to support Ethan, let me know. I'm sorry. I don't know if this is. I'm going to bring him back tomorrow morning at 8:30. I'm going to appoint him a lawyer, and then we're going to handle the contempt proceedings tomorrow morning. Okay? Thank you. Are you ready on the John Zeger matter?
I'm just going to show up there tomorrow morning at 8:30 and pretend to be his lawyer. I'm going to say he hired me. I'm going to make a fake P number. Though I don't know. I really don't know. And this is probably going to be stupid, but I only hear people say their P numbers in Michigan. But is it all over? Because they don't ask anybody else in my videos for P numbers, right? Do they? Hi, Cloud. Hi, Tammy. So I'm going to definitely have this court open tomorrow morning at 9:30 because they're an hour behind me. And we'll see what happens to Dad. And yes, Kelly, this is definitely Colorado. We're going all over the United States today. Just saying. Okay. So, this next clip, it's just 5 minutes long. It's oh, Fozzie, you missed some guy get arrested. For contempt. We don't see people get arrested for contempt. We see judges that say, I'm going to give you contempt. And then they say, okay, you're in contempt of court. And then they say, okay, never mind. All right, but next time. No, this lady, she's on it. This next clip is 5 minutes long, and it's in California, a new court in California that we didn't see before on this channel. Nothing happens, but I am going to pause it in the middle. First off, to make people mad who say I shouldn't pause it. Second, because I want to show you something.
You have a factual basis?
Yes, Your Honor. On or about December 17, 2023, the defendant, Kira Lee and Ilani Diwali entered a Target store. Working in concert, they took a sound bar and 2 TVs with their car into their carts, and they left the store without making any payment to the store with the intent to sell the items.
Thank you. And that was in Stanislaus County.
Thank you.
Thank you. The court accepts that factual basis, accepts the no contest plea, finds Ms. Duvall guilty of the charge in her case, count 1, 490.4 organized retail theft. And in Ms. Lee's case, she has.
Okay. Look at this courtroom. So, in the back, you see a lady sort of leaning over on her hand. All right. That's the co-defendant. In the front, that's a co-defendant. Okay. Both of them are wearing like that mango pink. Okay. Now, beside them are their lawyers. So they threw one lawyer standing back there. He doesn't have a place to sit. He doesn't have a table. And then the other guy, the smaller lawyer at the table, he's sitting elbow to elbow beside the prosecutor. That's the prosecutor right there. And they're arguing their cases right beside each other. Isn't that crazy? That's not. And then look at it. The prosecutor's huge. He's a big guy. Then the lawyer, her lawyer is just this little guy. I feel like, if he says something the prosecutor doesn't like, he's just gonna pound him right there. It's this court setup is crazy. All right.
Also, 490.4A1 retail theft and 148A1 resisting, delaying, or obstructing. And there's time away for sentencing. Mr. Shum?
Yes.
Mr. Ricks?
Yes, Your Honor.
Okay, so ladies, I'm going to order your terms of probation. Everything I'm telling you now is written out for you on the paperwork. There's a little bit of differences, I think, between the two of you. So Elani Deval and Kira Lee, it is the order of court. Imposition of sentence upon you is suspended for 12 months. Do I have your attention back there? Yes, okay. Mr. Shum is right in between how I can see you on this. Obey all laws, obey all court orders, notify the court immediately if you change your address. For each person, you're ordered to submit your person, your vehicle, property under your control and at your residence to search to see whether you have stolen property in your possession and to search for burglary tools. Each of you is ordered to stay away from the Target store on Sisk Road in Stanislaus County. Each of you has a restitution fund fine of $150. There's a security fee of $40 for Ms. Duvall and of $80 for Ms. Lee, a conviction assessment fee of $30 for Ms. Duvall and $60 for Ms. Lee. The sentence for Ms. Duvall is 15 days in the county jail. She has 1 day credits. 15 days with 1 day credit. Also for Ms. Lee, you have to surrender to the county jail within 3 months or not later than the date of July 11, 2024 to serve out the balance of your sentence. Unless you've been accepted to a jail alternative program, you can apply to do a jail alternative if you wish to do that. And people move to dismiss. There's a count. In Ms. Duvall's case, count 3.
Your Honor, so just really quick, count 3 will be dismissed in the interest of justice in light of the plea. Count 2 was dismissed with a Harvey waiver for the search terms for burglary tools.
Thank you.
Your Honor, if I could address, I believe the count 2 was the resisting, which only Ms. Lee is charged with. I believe my understanding is that Ms. Duvall is charged with the 3 and the 4, that the count 3, the possession of burglary tools, would be dismissed with the Harvey waiver, and count 4 would be dismissed in its entirety. I believe count 2 only applies to Ms. Lee and not Ms. Duvall. And my understanding was, I believe the search waiver was only for burglary tools in Ms. Duvall's case,
Right.
which she
Whenever
is.
there's stolen property, there's a search term for stolen property.
Thank you.
I'm not going to change on that. Okay, so you agree then, Mr. Sandy, that you've got a count 4 to be dismissed?
Yes, Your Honor.
And who does that apply towards?
Ms. Duvall.
Ms. Duvall.
Yes.
Okay. So Ms. Duvall, do you understand your terms of probation?
Yes,
Do you accept probation on these terms? You promise to do these things?
yes,
And Ms. Lee, do you understand your terms of probation?
yes,
And you promise to follow your probation?
yes.
Okay, within 30 days, go to the collections office. Oh, and was there actual restitution
No, Your Honor, it's to reserve jurisdiction.
taken?
Yes.
Go to the county collections office to make an account for your fines and fees and contact the sheriff's work program unless you intend to surrender on your jail time. Thank you.
Thank you.
Thank you very much, Your Honor.
Thank you, Mr. Ricks.
So nothing crazy happened there. I just really liked the courtroom setup, so I just put it here. And we're gonna replay because Fozzie missed it. Here we go. Look, guys, it's just gonna take 3 minutes.
On all
Fuzzy,
Do you have
pay
a cell
attention.
phone with you?
do you mean, do I have a cell phone with me? Everybody has a cell phone with them.
All right. And did you record
I
court
just said, no, I
on your
didn't
cell
record
phone?
anything today. And I know why you're in here and I just clarified it. And it's right here. I've got the recording right here. I'd love to play
That
it.
is not a cell phone. That is an iPad.
Right. I didn't record anything on my cell phone here today at all.
Go ahead and play the item that you'd like to play for the court.
Sure. Okay. Thank you. So they did an illegal assessment. Adrian over there. So this is the weekend that I came in on a Friday to file.
Deputies, can I have one of you come forward, please, if you would kindly do a service for the court? Mr. Oberlander, could you open your photos and videos and just, I want to make sure that there is no video or photos of the court proceeding?
I'm gonna open all my stuff up. I mean, that's ridiculous. You told me I could play my one thing here. I clarified
did.
one reason that.
And I
this
just
is-
want to verify you didn't record court. If you don't want to, we will begin the contempt
I
proceeding
mean,
now.
why would you hold me in contempt? I'm not playing any audio in here at all for the court today.
Mhm.
I came in here to protect my son, and I clearly stated to him.
Court has continually expressed to Mr. Oberlander that he has been disruptive in the courtroom. The court has given him an opportunity, even though he has been in direct contempt, the court has given him opportunity to establish that he hasn't further committed contempt by recording the court. Instead of cooperating, he is choosing not to cooperate.
Choosing not
and
to
show
cooperate. I'm
that
showing
he
him
is
right
not-
here. What are you doing? Why are you putting things on record that aren't happening?
Are you showing him your
Yeah,
photos?
right here, yeah.
Pull up his recordings, Your Honor.
Yeah, it's right here.
Tuesday.
And I'd like to see photos and
No, I'm not.
videos.
Dude, that I'm not.
Okay,
I've
then
been sitting right there. Why do you have the right to invade all my stuff because you want to? There's no proof. There's no.
Mr. Oberlander, you have continually been disrupting the courtroom,
I was
and
continually
a
trying to
report was
stop-
made to the court that there might be a video or audio recording. I've given you an opportunity to let us know.
The camera's in here to see that I haven't video or audio recorded anything. You can look at all the evidence.
Given that this has been so disruptive and so extreme, the court at this time is going to hold you in direct contempt.
Your Honor.
The court has given you an opportunity to present any
Tase
mitigation,
him. Tase him.
and the court is going to take you into
Tase him.
custody.
Your Honor, can I at least play the recording that you said I
No,
could
thank
play?
you. I heard enough of it to know that that was not a recording of the court.
It's
I
not
wanted-
recording of the court. You
you
said I
wanted-
could play the recording
I
that I
wanted-
wanted to play.
You wanted to know that you weren't recording anything else. The court at this time will have you back
I just showed them that I wasn't.
tomorrow
recording
morning at 8:30 in the morning. We will have you back. We will appoint counsel to represent you for the contempt proceeding in the morning.
Your Honor, I'm sorry. I just showed them. Listen, I haven't had any.
Please do not
I
further
came-
disrupt court. Move to the side. You're going
Why-
into
Why
custody.
am I going into custody?
I've already made a record. Please go to the right.
How long am I? I didn't hear any of that, Your Honor.
I'll see you tomorrow morning at 8:30 in the morning.
Your Honor, I can't, last
To
time
the
I've been
right.
there, I didn't get any of the medical treatment I needed.
Mr.
I didn't get the-
Oberlander, do not make this go till next week.
Guys,
Thank
why are you
you.
guys taking all my stuff?
This part right here is my favorite
Okay.
part.
We will grab. Keep walking, Mr. Oberlander.
Your Honor, last time they did this, my US.
Mr. Oberlander.
I had broken evidence last time this was done to me.
Mr. Oberlander,
I love her earrings
Wasn't
too.
documented correctly and it was broken.
continuing to interrupt my
You guys see
courtroom.
what's going on here? I came here to defend my son that's being abused for mental ill that's not being properly cared for. Now I'm going to jail,
I hope you will
right? What
cooperate.
did I even do besides try to offer a recording to help protect my son? Did I do anything other than that?
Last time I did this, Okay, so this next one, I wasn't going to play it today. I was going to save it for tomorrow because I have plenty for today, but I can't save it. I'm not really good at saving anything. So I'm going to play it. And you just wonder what it takes to make a mother stand in court and say, I don't want contact with my son anymore. And,
We're on the record in 24M136, People versus Benjamin Hoshiko. Am I saying that name correctly? Hoshiko?
Yes.
All right. Mr. Hoshiko is present for court today from the Delta County Jail via WebEx, both audio and video. Ms. Van Soosbergen is representing him. She's from the Public Defender's Office. She's present in court in person. Mr. Allen is here for the District Attorney's Office, and we are scheduled for hearing on advisement. In this case, Mr. Hoshiko has been arrested on a new charge of violation of a criminal protection order as a Class 1 misdemeanor. Ms. Van Soosbergen, are you able to waive further reading and advisement as to the charge, possible penalties, and your client's rights?
Yes, Judge.
Thank you. Mr. Allen, what are the people requesting for protection order and bond conditions?
Your Honor, with regard to the protection order, we'd be asking for the mandatory here only. And with regard to bond, I believe Mr. Hoshiko's parents would like to, or one or both, or would like to address the court.
Somebody want to address the court about protection order or bond?
It's okay, you don't have to.
You don't have to, but if you want to, you'll need to come up to the podium.
Are you gonna give us a protection order bond?
If you want to talk about anything with me, it has to be at the podium because it has to be on the record. So feel free to come on up. And
Not exactly sure what you're asking me.
that
Spell it out.
okay, if you'll come to the podium, first of all, why don't you introduce yourself?
I'm sorry. I'm Diane Hoshiko. I'm Ben's mom.
Okay, you're the defendant's mother?
Yes.
All right. And so what I have to decide today is whether to release him from jail or what on a PR bond, personal recognizance, or whether to impose a cash only bond that could keep him in jail. And along with that decision is what kind of, if he's released, what kind of requirements should be on him. Protection order provisions can be put in place. That can be, regarding controlled substances, weapons. It can be stay away from an address or no contact with a person. So all of those are options. So what would you like to tell me today?
Well, I would like to tell you that Benjamin cannot come back to our house.
Okay. Are you asking for an order that he stay away from you?
Yes.
Okay. And you said our, that's plural.
My husband and
Okay. And are you wanting to be able to have any contact with him whatsoever, like phone or text or third party or?
I myself don't want to have any contact right now. I can't speak for my husband. I feel like that I'm really afraid. And so I would prefer right now not to have any contact with him.
Okay. Is there anything else that you'd like to say about protection order or bond?
No, just that I know they found the Drano and all this stuff in our house that can be a precursor to making a bomb, and I'm scared.
Yep.
And I don't
Bombs.
hearing him talk about wanting to kill cops makes me afraid for police officers. And our police officers protect us.
Okay.
We don't talk about killing them. So
Okay.
I am scared. And so I would just say that we would like to have a, if you call it a bond or whatever it is, that restraining order or whatever, we'd like to have that.
Okay.
And then have Benjamin go to Adams County where they will, he can finish out his probation.
Okay. I didn't realize he was on probation. According to the report here, looks like he's on parole. Maybe that's what you
Oh,
meant.
that's what I
Is that
mean
what you
on
meant?
parole. Yes, I'm
Okay.
sorry.
That's okay. All right. Do either of the attorneys wish to ask her any questions?
I don't, Your Honor.
Not at this time, Judge.
All right. Thank you. You may sit down.
Thank you.
Scary dude, guys.
Mr. Allen?
Yes, Your Honor. nobody else would like to address the court on that. So with regard to bond, in this case, the court under 16.4.1035 can look at several different factors. One of that is the nature and extent of family relationships of the person, past and present residences of the person in custody, character, reputation, prior criminal record, and any facts indicating the possibility of violations of the law if the person in custody is released. Now, while it's not charged in this case, what we have here is a violation of a protection order. I do think, however, the comments made by Mr. Hoshiko's mom here and the other facts in the affidavit are relevant to bond and release. There's been talk and speculation. Well, at first, the defendant was residing at their house, and as Ms. Hoshiko stated, he is no longer welcome back there. So that currently leaves Mr. Hoshiko, I believe, homeless or without a place to stay, and his family and parental ties are limited here because of what Ms. Hoshiko stated, that they don't want him back, they're scared. There's talk of potential bomb making, but as well, that's not in front of the court on this case. I think it does factor into the potential violations of law under 16.4.103 and his strong indications of wanting to harm law enforcement. And so with that, we do think a cash bond is appropriate here, as well as his criminal history. He's on parole currently for a second-degree assault from 2016, and he has 2 prior felony convictions, one for felony menacing and one for first-degree criminal trespass, both showing kind of a violent history there. So all that taken into account, the people are concerned for the public as well as Mr. and Mrs. Hoshiko, and would ask for a $2,000 cash only bond.
All right. Mr. Allen, what are you, sorry if you're repeating yourself, what are you asking for in the protection order? I need to know if you're wanting to list people as protected parties. If you do, we need all of that demographic information.
Correct, Your Honor. We are just asking for the mandatory protection here.
Okay.
We have spoken with Mr. and Mrs. Hoshiko about potentially applying for a civil protection order.
Okay. All right, Ms. Van Soesbergen.
Yes, Judge. So, Judge, we are asking the court to impose a personal recognizance bond in this case. I'll note the statute to which Mr. Allen cited, 16-4-103. Again, as I've stated before, the considerations before the court are, again, the presumption in favor of pretrial release with the least restrictive means necessary to ensure appearance before the court, as well as community safety. So I do want to address community safety first, since that seems to be the thing that's most at issue here. First, the allegations in the affidavit are completely uncharged. It is, at this point, it's speculation. I think that if there was such a strong community safety concern in order to merit holding Mr. Hoshiko in custody on this case, certainly I would expect that he would be charged with something relating to those allegations. At this point, since he's been uncharged, my assumption would be that there is not enough evidence of those crimes here. Certainly the officer in this case only charged Mr. Hoshiko with a misdemeanor in the first degree, violation of the protection order. And I think that, Your Honor, is what's at issue here. And I think that, Your Honor, is the community safety that this court should be looking at as to the charged conduct rather than uncharged conduct. I'll note that certainly if, community safety wasn't an issue as the protection order, I think that the appropriate move for the court here would be to issue a criminal protection order against the alleged victim here. And I'm just looking for her last name. I know her first name is Pamela.
You don't mean against, do you?
I mean a protection order prohibiting contact as well as a vacate stay away. Given that,
Yeah.
again, the allegations here, I'll just note that they're limited to telephone conversation, it looks like. So not in-person contact, nothing rising to the level of assaultive contact, or even really, I would say, harassing contact here. So I would note that. I think that the facts here are mitigating, and certainly if this court is looking at the least restrictive means necessary to ensure community safety, I think that the appropriate order here would be a protection order with a protected party as Pamela, prohibiting contact, prohibiting a vacate stay away order here. So that's what I argued to the court as in terms of community safety. As to appearances before the court, Mr. Hoshiko has 0 failures to appear within the past 5 years. He does have ties to the area here. He has a vehicle and a driver's license, so transportation to and from court wouldn't be an issue. I'll note that he does have ties to the area. While, again, I'll acknowledge that this is disputed, he was previously living in Hotchkiss with his mother and his father. It doesn't sound like there is going to be a vacate stay away provision here. Mr. Allen certainly hasn't asked for that. I question whether or not the court can impose it under 18-1-1001, given that it needs to be against a witness or a victim. But I'll note that really the issue's moot because it hasn't been asked for. Certainly, they're free to pursue.
I have a person in the courtroom that asked for it.
That's correct, Judge, and I understand that. But I do think that it is persuasive given that it doesn't seem like the district attorney is asking for that. Rather that it seems like Mr. Allen indicated that a civil protection order would be pursued. And I don't think that that's at issue at the case here. I'll also note he's given me both a phone number and an email address, so he's given me good contact information. And I'll also note that he did share with me that he's been working with parole. So it sounds like he's been in contact with his parole officer. It sounds like that's been going pretty smoothly for him, at least according to my conversation with Mr. Hoshiko, according to my understanding. I'll also note that, again, I really don't want to address specifically the allegations that were noted here, the allegations that are uncharged, but Mr. Hoshiko does vehemently dispute those allegations. And so, Judge, I do think that personal recognizance release is appropriate here, given the record that I've made, given his ties to the area, given his contact information, transportation, his complete lack of failures to appear in the last 5 years. He is willing to work with pretrial services, certainly willing to work with his parole officer. So I don't think that appearance before the court will be an issue here. And certainly I think that there are other routes that the court can take in order to ensure community safety. Again, I'll make the record that I do think that it is community safety as is to the charged conduct here. Again, the violation of the protection order. Thank you.
All right. So in making the decisions here regarding protection order and bond, of course, I consider the arguments of the attorneys and the statutory bond factors, statutes cited by both attorneys. I do consider the facts and circumstances as alleged in the affidavit, as well as the defendant's criminal history and the information in the pretrial services report. The Delta County bond guidelines recommend that the defendant be released on a personal recognizance bond with no supervision. That is based upon the level of charge as well as the risk category. I acknowledge that the risk category is a low risk category. I also acknowledge that this is a misdemeanor offense, and that is why the bond is recommended that way. That is, however, a starting point, a presumptive type bond, and the court is not required to follow that recommendation. I'm just required to consider that. I am also considering that Mr. Hoshiko is on parole for a Class 4 felony after having been released from prison for assault in the second degree causing serious bodily injury. He was sentenced to 9 years of prison 6 years, less than 6 years ago, 5 years ago, and some change. And that was for the victim named in this case. Pamela Hoshiko. And part of the requirements in 16 CR 1622 out of Adams County was that he have no contact with her whatsoever. I don't know how long he's been out of prison, but it can't be that long. But anyway, regardless, in this case, there is probable cause to believe that he did contact the victim of 16 CR 1622. I do understand what Ms. Van Soesbergen is saying, that if I should not impose a bond regarding uncharged conduct. However, what I have here is contact with the victim of the felony assault that he's on parole for. And I do think it's appropriate for me to consider the behavior as is outlined in the affidavit. And there is certainly concerning behavior that could be dangerous for the victim of that assault if he is contacting her. So I do consider all of those things when deciding on protection order and bond. In the protection order is a mandatory protection order, and that is that he shall not harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts he's charged with committing. The district attorney is not asking for me to impose any additional conditions, so that'll be the protection order. As far as non-monetary bond conditions go, the protection order is a bond condition. I am ordering, if he is released, that he comply with intensive pretrial service supervision, no possession, purchase, or control of firearm, ammunition, or other weapon, controlled substances, alcohol, or marijuana. That, I'm sure that's all consistent with his parole conditions. As a non-monetary bond condition, I am going to order that he stay away from 33207 J80 Road in Hotchkiss, Colorado. I'm not going to make that a protection order condition because the people didn't ask for it, and Ms. Van Soesbergen's objection and comments, but the bond conditions statute gives me more leeway than the protection order statute, arguably. So I am going to make that a non-monetary bond condition. For the reasons that I've stated, primarily the fact that he's on parole for the class 4 felony assault 2 serious bodily injury, and then he has 2 prior felony convictions for trespass and felony menacing domestic violence. I am in agreement with the prosecution that a PR bond is not appropriate in this case. I am very concerned about public safety in this case, based upon the allegations in the affidavit and his criminal history and the fact that this behavior is occurring while on parole. And so I will grant the prosecution's request for a $2,000 cash-only bond in this case. Mr. Hoshiko, while you're in custody, do you want to be represented by the public defender's office?
I want a lawyer right away.
You have a lawyer here today, so I'll appoint the public defender's office to represent Mr. Hoshiko.
Hold on a second.
And, Mr. Hoshiko, I didn't ask for you to speak right now. I just asked if you wanted a lawyer.
Yes.
Thank you.
Yes.
All right, we will appoint the public defender to represent you. And then we will bring this back. Ms. Van Soesbergen, do you have a request?
I'd ask for Tuesday, April 16th.
Assume that's fine, Mr. Allen?
Yes, sir.
All right, this matter will be brought back on Tuesday, April 16th at 2 o'clock and will be scheduled for appearance of counsel at that time. Thank you.
Scary dude making bombs, wanting to kill cops. His mom won't even talk to him. I wonder who that woman is, though. This has nothing to do with anything that just happened. But I wonder who that woman is in between the husband and wife, right there in the back row or in the second row. Because he's sitting right up next to her. And when the mom came up to talk, he raised his hand saying he was the husband. And he has like full body contact with that woman right there. Oh, I'm sorry, Tammy. Listen, we all hope that it goes well, and you have to let us know as soon as it's over. We're going to be waiting to see how your surgery went. Okay, so now we're going to Fleischer, guys. It's time to go to Fleischer. Let's go.
So it was 6 out of 6 HGN, 3 out of 8 walk and turn, 3 out of 4 one leg stand. Defendant was read GIC and refused to provide a breath. Blood warrant obtained and executed.
Do you have a Texas driver license?
Yes, sir.
Do you have liability insurance in your name?
I believe so with my dealership.
There's no, I believe so. I'm going to order you not to drive until I'm 100% sure that you have valid liability insurance in your name.
Yes, sir.
So I'm as of right now, until I know 100% sure, you're not allowed to drive. You have a lawyer that's coming. When your lawyer comes, you guys can verify that, yes or no. But at this point, I'm ordering you as a condition of your bond not to drive any vehicle that's not equipped with an ignition interlock.
Yes, sir.
If you're caught driving a vehicle that doesn't have an interlock, you will go to jail.
Yes, sir.
Do you understand?
Yes, sir.
I'm also ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. As it stands now, you're ordered not to drive until you prove it to me that you have valid liability insurance, man. If you're caught driving in violation of this court order, I will have a contempt hearing. You'll be facing an additional 6 months in jail every time you drive. I'm gonna have you come up here, swear to us that you're not gonna drive. After that, you'll get to Victoria. We're gonna have you sign a reset. Then you'll get with Jeremiah for your bond conditions, and then we'll have you wait for your lawyer. Mr. Perez. Okay. You have an offer on this case? You have an offer on this case? Do you mind putting one on there, please? This is Camille Brown. If you ever take off again, Miss Brown, I'm going to make your bond 10 times the amount it is now. Do you understand? I'm not going to entertain any excuses. Your case is now 170 days old, and it's time to make a decision. So I'm going to give you 2 weeks from today. I'm going to have you meet with your lawyer, and it's time for you to decide what you are going to do. In 2 weeks, you will come back. If you have not accepted a decision, whether to accept the plea bargain, I will set your case for trial. Do you understand, man? No, it doesn't matter. There's no way you can justify taking off 4 different times. It doesn't matter. The only thing I'm going to tell you now is that at the next setting, it's clear trial. Do you understand? Okay, I'm going to have you sign a reset, and then I'm going to have you take your seat in the jury box while I get in contact with your lawyer right now. Jeremiah, can you make sure that she has a device, please? This is Brown. It's a DWI second. Can you see what she has? Does she have an interlock? Does she have a portable device? Okay, she doesn't have one now.
No, because her conditions aren't valid anymore.
Okay, Miss Brown, sign your reset, and then I need to talk to you again, please. Okay, she did. All right, come up. This is a DWI second, so you're supposed to have a device. Do you have a Texas driver license?
Yes, sir. I do have the device. Whenever I had the device at first, and I still have it at home, but I have to get it redone. But because I went to mental health court. I was in jail whenever all this was going on. I ended up going to jail and getting mental health court and started getting help. I brought all my stuff to show you if you.
I don't have any kind of notice of anything. The only thing I have are bond violations that you were ordered to obtain a device and you failed to obtain a device.
I remember I came back and I did obtain the device. And my lawyer and we spoke, my family spoke to my lawyer And he said that he let you know that I was in jail. I've been in jail since December 28th, and I got out March 15th. It was in
How are you in jail? And where were you in jail?
Galveston County.
Can you run an NCIC, please? So you have an open case in Galveston County.
It's closed now. I'm in, and I'm on mental health probation, and
So you're on probation now.
yes, sir. This is my certificate and everything. I actually leveled up last week, and I have a therapist. They actually wrote a letter to you, but I sent it to my lawyer. If I would have known that he was gonna.
You should, I don't know if Carl knows that you're going to be here today. I'll read.
He's the one that sent me the notice that I had court today.
So he'll be here today.
Yes, sir.
Okay.
Yeah. I appreciate it.
Okay. Just take a seat for me in the jury box. I need to do a little bit more deeper dive with you, man. Anna. Hey.
He definitely
I'm
made
here on
these
Fugitive
noises.
Okay.
He's doing, I don't know if you remember his case.
I remember.
He's doing a mental health PTI. We are still trying to get an appointment at the Harrison. He's making efforts to do it. He just can't get in touch. I've got a max social worker.
We're going in circles because this is like 2 months now that he can't get.
Well, it's only been 3 weeks that he was offered the mental health PTI.
No. But remember, it was like a month ago, he was offered the program,
Yes.
right?
And we executed the contract and he's been.
We gave him 2 weeks to try to make the appointment. You came back, he wasn't able to do it.
Yes.
Have you reached out to Brad Morris?
I have, and he's trying to get someone to reach out to Mr. Nguyen. It just hasn't been successful.
Meaning they have not to Mr. Nguyen.
Correct. He just needs to get the appointment to go to the interview.
Okay, where's Mr. Nguyen now?
He's right here. It's not a lack of effort. It's just.
Can we have him call now out there and try to make the appointment right now?
Sure.
Okay, have him do that. No, let's see. Okay.
So Your Honor, on the Galveston information.
What was the charge? So it was a felony,
State jail.
state jail,
Yeah,
and
2 years, probated for 2.
straight or deferred?
Straight.
Wow.
And Galveston, supervision office, like, took custody of the jail. So they put her in mental health.
Does she have any priors?
She does. She has a DWI, she has assault and battery out of Virginia. Here she has fraud and this DWI. That's it.
Okay, is discovery complete on our case?
Let me take a look, Your Honor. Yes. In terms of the case in sheet, yes, we're just missing her Janus out of state, but I can see it today.
Okay, so I'm gonna give them a couple weeks to see what they want to do. If you can go ahead, please put an offer and then, so Jeremiah, 3 days, please, to get it working. Okay, waive the fee. Okay. Who is on the iPhone?
Judge, that's John Anderson. I came in to talk to you about yesterday. I was on the docket yesterday and it didn't get calendared, and my client's appearance was waived and there was a capias issued. I'm so
No
sorry.
one showed up for 2 days. We had no idea what's going on, so we issued the warrant, you know?
Yeah, I understand, Judge. I apologize for that. That's my fault. It didn't get calendared. I had somebody covering for me the last setting, and whenever he notified my office of the date, it didn't get calendared, and I apologize, Judge, or else I'd have had somebody covering for me.
What's your
Is there-
cost, please?
It's Christopher Hanold, Hannold.
What's the cause number?
I'm gonna have to look it up, Judge. I apologize.
Get a copy of this? Yes. Okay, great. We'll do this next after.
And Judge, just so the court's aware, we've been in talks with the DA about Veterans Court on this case. Just trying to hammer out what I need to do for him to get into that.
And he didn't respond to you? The problem is that no one came here, and our court emailed you twice and we never got a response again with regard to the emails as well. I'll reinstate your bond, but this can't happen again.
Yes, sir. Yes, sir.
I will not do it again, okay?
I understand. Yes, sir, Judge.
Judge, in the notes I have is applying for escort, has that happened yet?
No. And what do we need to do, Pavel, for vet court? What does he need to do?
The defense actually needs to apply to the court itself. There's an application process. And Veterans Court, if they, in the event that they accept them, that would move that case to their docket.
Where does he go specifically to how to apply, you know?
I don't know, Judge, it's through the court, it's through the administrator there.
Let me,
Yes.
Thank you. So you can put your hand down and you can have some.
No. She called.
Judge Giles would have nailed this attorney to the wall.
Mr. Hanold, what is your email address, please?
This is John Anderson. I'm Mr. Hanold.
I'm sorry, Mr. Anderson, what is your email address? Okay, I just sent an email to Nathan Beadle, okay, to see how we go about doing this. So if you want to bear with me just a little bit, let me see what he's usually really good about replying. If you give me maybe like 10 minutes to see how he replies, I would normally reset your case, but your case is already old. It's over 180 days old, and it's now time usually that we set these things for trial. So just bear with me a bit, okay, Mr. Anderson?
Okay. Yes, sir.
Thanks.
Thank you.
Anna.
So Mr. Nguyen and I reached out to the Harris Center together. The woman that coordinates this program, she's in a training this morning. They don't.
Wonderful.
After lunch.
Okay.
They have assured me that she will give both of us a call back.
Okay.
To set up the appointment. So I don't.
Okay, I'm gonna roll it to Monday, just because it's too old. Let me see, Nguyen.
You should judge.
See how, yeah, it's 260 days old. No more long resets until we get this thing done. So yeah, let's roll it to Monday and see, hopefully you can get a date. You know, if not, if you don't get a date on Monday, then I'm gonna call myself. It's ridiculous that it takes this.
Cha, I miss Judge Kim Hall.
Yeah, she's really good at everything there.
We're just getting an occupation or something.
Mr. Nguyen?
Okay.
Lisa Smith.
Around.
She on probation. She's in compliance.
Oh, she just was placed on probation. I mean, I'll double check, but
Just-
she hasn't done anything yet.
Okay, counsel, please let your client know that she must remain in compliance on probation. The first instance she's out, we yank the license, okay?
I'll make that very clear.
Okay, yeah, I've granted it for you then.
Okay, yeah. And we know you'll do it.
What's that?
I said, we know you will do it.
Yeah, well, I want to make sure that they do what they're supposed to. Yeah, it just.
Are you making us copy? Or are you making us copy?
Do you know who got Harvey? Remember the case? No, what court it went to? Oh.
We never get an answer to that. No one answers him where Harvey went. I don't know what judge he went to. I don't know if I can find him.
Joseph Henry Perez. Mr. Perez, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you, sir.
On December 3rd, 2023, in Harris County, Texas, officers responded to a call for service at a residence. Complaining witness stated defendant is her ex-boyfriend's uncle. Defendant came over because he was mad. Complaining witness's ex-boyfriend that went to jail left her his car instead of leaving it to the defendant. Defendant became aggressive and tried to take the keys, but complaining witness did not let him. Complaining witness stated defendant wrapped his arms around her neck, causing pain and applied pressure using both forearms. Pain level was a 9 out of 10.
You have the rip done. By chance, do we know whether
I can try to rip her right now.
I'm just going to order regardless, no contact. All right, Mr. Perez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. Do you understand?
Yes.
If you violate these conditions, I will put you in jail. You will not get a PR bond. Can you give me a PSR?
I don't have a copy.
You ready?
Your Honor, may I say something?
No, just give me a second. 2,500, 250. So as it stands now, Mr. Perez, you have a warrant for your arrest. I'm going to give you a PR bond today so that you don't go to jail.
I don't understand what PR means.
A personal recognizance bond so you don't have to pay to get out.
Okay, yes.
This is the only one you're going to get from me. If you violate these conditions, if you pick up a new case, you do something to violate the law, I will revoke this bond. I'm going to make it high and you will go to jail. Do you understand now? Okay. I'm going to set your bond at $100, but I will give you a PR bond. And then I see that you do have a lawyer. I don't know where he is. We will wait for him to come. I know Mr. Goodman. He'll be here at some point. Did he tell you he's going to be here?
Yes, so he says he's gonna be here at 9:30.
Okay. Well, lawyers are notoriously late.
Okay.
Some.
More some more than others.
Judge, what was the bond amount?
$100. So because you have a lawyer, I will waive your appearance. You do not have to waste your time coming to court, but you must stay in touch with Mr. Goodman and he will tell you if and when you have to come back to court. If Mr. Goodman comes back to me, tells me he can't get a hold of you because you're ducking and dodging his phone calls, I will issue a warrant for your arrest. For now, I will have you go sign a reset with Victoria. Then we will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. We'll have you sign your PR bond, and then we'll have you waiting back for your lawyer. Please. Give me 1 second, Mr. Anderson. Hold on. Hold on.
Yes, Your Honor.
Do we need to file bond conditions or?
Please, yes. Yeah, because I'm not having it monitored. So if you just file no contact and no weapons, please. Mr. Brasher.
Yes, hey, how you doing, Judge?
Hey.
I wanted to approach on George Ford.
It's 31.
Let's see.
Medina Jesus.
Okay, so I wonder why you didn't get a PR bond.
That's what I'm wondering.
Let me look up. Let me look at what the magistrate said.
Okay.
I'll read it to you.
Okay.
It says, I find by clear and convincing evidence that there are no non-financial conditions of bond that will suffice to reasonably assure public safety for the following reasons. Allegedly seen breaking into a car and taking complaining witness's purse. Per PDO only makes $1,500 a month, alleging financial affidavit incorrect.
Wondering why given a PR bond on it, Your Honor.
Maybe because they're potential file theft of a person, felony charges. I don't know. Do you mind bringing Mr. Ford out, please? You know, the other problem is that we've had a lot of cases with him.
I see that, but it looks like he mostly has a lot of misdemeanors.
But it keeps happening, and in our latest one, he was MIA a lot on the indecent exposure and failure to ID. So I'm always down for giving someone a chance. You know what I mean? At least once. So I will give him a chance, but only one, and I'll let him know. So that way he's properly informed. But I'll give you one PR bond. Hey, so on Ford, the magistrate didn't give him a PR bond. I will one time, but I'm going to admonish him.
Okay, who's the co-defendant?
That's a good question.
That
You
is,
said 31, right?
Tracy Cutbirth.
Do you have a case number?
Yeah, let's see if we can transfer it out. Oh, no. Right.
186-3294.
That's a felony case number. 186.
3294.
It's a felony. Okay.
Credit card abuse. So it must have been, dude takes credit cards out of the person, tries to use it. That's what I would imagine, right? Mr. Ford, how's jail?
Not too good.
Really?
Yes, sir.
You just can't stop picking up cases, one after the other after the other. Let's look you up. All right. Since 2021, for the last 2 years, evading arrest, burglary of a habitation, criminal trespass, unauthorized use of a motor vehicle, credit card abuse, assault, bodily injury, evading arrest or detention, failure to identify oneself to a peace officer, indecent exposure, failure to ID as a fugitive from justice. And now you pick up a BMV where you allegedly take a purse from a woman at wherever it is. Was it a gas station?
She took it, well, he took it from complaining witness's house.
From a house?
It says she noticed that.
Well, let's do PC. I guess I didn't, please.
On April 8th, 2024, officers arrived at a convenience store located in Harris County, Texas, where they met with a witness who advised that they observed a black male wearing a red shirt break into his neighbor's vehicle and then ride off on a black bike. Officer then went to complaining witness's house, located also in Harris County, Texas, and met with complainant. And complaining witness stated she noticed her handbag was missing. The complaining witness was advised that her debit card was declined at a gas station named Mike's at the gas station previously mentioned in the OR. Officers were able to locate the defendants who matched the description along with another male late ID as co-defendant. The officers met with a witness who stated that the co-defendant was in possession of the stolen cards and as officer approached, went into the laundromat and threw down the brown purse. The officer searched the laundromat and was able to recover the stolen property. So it was a vehicle, stolen from a vehicle.
How do we link him taking it?
He matched the description of the surveillance that where the credit cards were used. The co-defendant was using the credit card, but he was right by him. They were in the same clothes, right on the corner, and that's where they arrested him.
But do we have something putting him in the car taking it?
The witness, the owner of the vehicle.
She saw him going into it?
Yes, and described the red shirt and then.
Okay. So, Mr. Ford, I'm going to find that there's probable cause to go forward. Why would we give you a PR bond, Mr. Ford? Really? Oh, you've touched my heart, Mr. Ford. That's why he didn't get a PR bond. Because it's over and over and over, and you just don't get it. So, why would we give you a PR bond? If history is any indication.
I'm trying to get my life together, Judge.
In 4 months, you'll pick up a new case. Where do you live? Who with? Who with? Show me that he has a place to go to, that someone's going to take him. He's got somewhere to go. And then I'll think about it but I'm not letting him loose on the street. And not only that, but I'm going to give you a GPS monitor and I'm going to give you curfew and I'm going to have you take drug and alcohol tests all the time. I'm going to make your life a living hell because for the past 2 years, you've picked up 20-something cases. I'm not going to make it easy for you, Mr. Ford. Thanks, you.
As far as proof goes, I know he watches over his wife and they live together in an apartment. And then he also has a job, a part-time job is landscaping. So he spends half the time in what caretaker for his wife.
Caretaker? You're going to take care of someone else when you can't even take care of yourself, Mr. Ford? Please. Let me know if he actually has somewhere to go, and then I'll consider it for sure. Okay? Thanks.
Do you need the address or serve?
Call wife, see if he actually lives there. He's allowed to go there and stay there, right? And then if she says yes, then I'll grant him a PR bond. But I'm loading him with conditions, Yeah. Thanks, Carl. Yeah.
Camille Brown.
So,
She was in jail in Galveston for some time because she was on probation.
Yeah. Okay.
We had a hold on.
Okay. Discovery is complete in the case, so I'm going to give you a setting, and then when we come back, we got to figure something out. So they've given you an offer. She's got 3 days to get the monitor back up and going because it's a second, and then we'll go from there. I will give you a full setting to get it done because I know you're busy. And then, hey, so initially I said 2 weeks, but I'll give him on Brown full setting, and then yes, because it's old. Yeah. Okay. Thanks, Carl. You're the best. Hey, Whoa, look who it is. What's up, stranger?
I just wanted to say hi. I haven't seen you in a while.
Yeah, how are you? I don't remember. Where you been? Are you still working with Mike or no?
Yeah, I still have her online, but I just came here for Ben.
Are you mostly on your own though? Mostly on your own?
Definitely. I mean, I've never worked for Mike. I always
Right.
office with him. So yeah.
Great. Good to see you. Shit. Yeah.
Hope you're doing well.
Yeah, thanks. You too. Okay.
Never mind, Judge.
But Hollins wasn't brought up.
Just say hi. Good morning.
Good morning.
How are you?
Yes, Judge, Hollins wasn't brought up because he's extremely ill. He was in a car accident. He was in critical care for, after the arrest, I believe until yesterday. But he has a warrant out of Missouri. Wondering if the court would set a bond so that he could make that bond and then go address his issues in Missouri.
Not without being able to admonish him, because let me see what it is first, I guess, without saying.
Misdemeanor case is in Missouri.
And
did I give him a prior bond day?
And that's what I was gonna bring up. He actually had a previous warrant for the same case, but it was a different KPS. So he was returned to the jurisdiction and then he absconded again on the same case.
No.
Okay, so how does he resolve it?
So what happens is we need to get him up here. So,
He's in the infirmary, as I understand it.
there's always a way. Always a way. So no matter.
He's actually in the hospital.
Yeah, he was in a serious motorcycle accident.
Do we know how bad the extent of his injuries are? He's gonna live, right?
Well, I believe he's gonna live, but yes, I believe that he is pretty serious. He was in critical care.
Being that I've already given him a bond and he's absconded on me, I usually never give someone a bond a second chance anyways. So.
Oh no, Judge, it wasn't that. He was previously apprehended. Hold on. I don't want to misspeak.
Did I give him a bond? Because if I gave him one bond and he absconded on me, I'm not going to do it again.
No, it was he was previously held, but the dismissal was before my time. It stated the demanding jurisdiction released or hold on the defendant, and he had a court date on December 3rd, so he was admonished to return to the jurisdiction. At some point, he must have responded because this is a brand new capias on the same case.
It's a new situation, but he did go to Missouri and hired a lawyer there and everything. He missed a court date in December, and I think that's what this is related to.
Yeah. If you give me a letter, I can check in with my guy, make sure that if we are good. Appreciate it. Yeah. Give me some first. Yeah, sure.
I guess. Hey, can you help me out on a new issue, please? No. We got him today and I gave him a PR bond. Please, yes. Tell me when you're ready. It's 2504 970 on Hollins. He's in critical care in the hospital here in the jail. He has a fugitive case out of Missouri. And defense lawyer here wants to give him a bond, but I have to admonish him. He's in the hospital though. So I don't know. That's a good. Right. How can we work that? Well, that's why I'm calling you to see how we can work that. Is there a way? No. I want him to make a bond. He's got to make a bond. I don't know. I don't know the extent of his injuries. I don't. Okay, and then you want to just call me? And then I'll get the number for defense lawyer and then I'll powwow with Day and then with defense and then we'll go from there. Figure it out. Okay, thanks. Okay, so what we're gonna do is this, I'm gonna get your cell phone because she's gonna reach out to the hospital to see how bad of condition he's in, to see what we can do, because that's gonna dictate how bad he is, how good he is gonna dictate how we go forward. Regardless, he has to sign the bond and he's got to sign the reset. I cannot release him until he actually signs the bond and the reset. Somehow we have to maneuver that way. I don't know how. So Sylvia's going to look into it with court management, and then I will call you when she gets back to me, and then I will three-way with Day so we can all figure out a way that we can do this. However you want it. It doesn't matter to me. So if you just give me, and then did you guys file an attorney of record yet?
I did, I found it under my name.
She's attached, Judge.
Okay, so Day, as soon as Sylvia gets back to me, I'll call you guys and then we'll powwow about how to do this. It's just, I'm leaving now in about 5 minutes. And so,
Yes,
it'll
Judge.
it'll probably be in the afternoon sometime.
Okay.
Okay, for sure. Okay. Thanks. Okay, hi, Jim.
Yes, just real quick. Three cases. First is Mr. Wright. He had a criminal mischief, but he also has a warrant out for another criminal mischief. He's supposed to be in court today, but he's not. I don't think he's coming, so I just wanted to bring that to your attention.
Yes. He was supposed to be here, right? Okay, I'm gonna revoke his bonds. I remember this dude. I've had a lot of issues with him. So I don't know what I'm gonna do it yet, but it'll get revoked.
I just want to bring it up to your attention.
Got it.
Next is Mr. Andrews in
Then-
custody, Judge.
Hey.
Andrew? Oh,
If you wanted to withdraw,
Yeah,
I'll
no.
revoke it. It's up to you.
no worries. Thank you, sir. Next one, Mr. Andrews in custody.
Revoke all the bonds, but I don't know yet. I'll do it later. So now we're on Andrews. Robert?
Yes, Mr. Andrews is in our court for a theft, but he has bigger issues in the 185th. He's due to go to court on the 18th. I'm just requesting the 19th. Paul, I think
Yeah.
most likely we can work.
That's a Friday. How about Monday?
Oh,
Yeah,
whatever you guys
just
want,
one day next, the following day.
whatever.
And then lastly, Judge, I have a bond case, Mr. Paul, state still needs to rip, so I'm just gonna reset that. Prawl. Mr.
You got
Prawl.
Mr. Prawl?
Yes.
Got it. Okay, thanks, John.
That's it.
Morning, Your Honor. Now, step forward for me.
Okay, who do we have here?
This is Miss Morgan, Your Honor.
Miss Morgan. Sharia Morgan? Good morning, ma'am. All right, so you are charged with terroristic threat. You're also charged with assault bodily injury. On your terroristic threat, you're facing up to 6 months in jail and or a $2,000 fine. You're facing up to a year on the assault case. What have you guys worked out?
She'll plead on the terroristic threat and the assault and dismiss.
Okay. What time?
We made a time served offer on the terrorist.
Got it. 114 with 140? All right, so you've worked out an agreement where they're basically offering you time served, 114 days with the credit that you have. You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this. Understand, Ms. Morgan, because of your prior criminal history, from now on, if you pick up any more misdemeanors, you will be facing a minimum of 90 days in jail. You understand?
Sir.
How do you plead to the offense, ma'am? Guilty or not guilty? Is it enhanced, Mr. Mueller? Do you know? Let's see. You are enhanced with your prior possession of marijuana out of court 7 from 2015. Did you have that case, in fact? Did you have a prior possession of marijuana case? All right, true to the enhancement. Good luck to you, man. Thanks, guys.
Judge did us dirty today. Okay. And I'm so mad at myself. And you'll find out why. Okay. So this was the morning docket. And he sent a couple people over to the side. You go sit over there and you wait for your attorney, blah, blah, blah. And he's telling these people, you know, hey, listen, I have to go in 5 minutes. I have to leave. We'll do this afternoon. We'll do this afternoon. So, hi, Diana. So, I swear I was like a teenager with her first crush. I kept checking this stupid stream like every 2 minutes. I kept checking his stream all afternoon long. And, you know, I had other things to do, but I kept checking and I kept checking. And every time he wasn't there, I was like, how rude why is he not there? So he never did an afternoon stream today, even though he said, hey guys, we're gonna do this afternoon. He didn't stream it. So I waited and waited and checked and checked and checked. And he never texted me back. He never called. He ghosted me all afternoon. Yes, I am a professional. Hey, I didn't mute any important clips today yet. Okay, so we have one more clip. And I'm warning you now, in case you gotta go, it's 50 minutes long. So I know we've already been in here a while, but I'm gonna play this. This is a divorce gone wrong. Let's just say a divorce gone way, way, way wrong for somebody. And okay, so this is Wisconsin. So these are the hardest clips to get because there's hundreds and hundreds of links and only like 5% of them ever stream and the rest don't. And there's no way to find out which ones are going to stream and when. You just got to be stupid and click through them. And I am stupid, and I do every once in a while. I'm like, hey, let's check out Wisconsin. Click, 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 click. So I found the same judge that I found last time, Judge Frost, and he does, you know, divorces and family court. So I got this clip because it's interesting. But I think, got this clip to troll some of the people who leave comments on my channel about how unfair the justice system is to men. So, so I expect a whole bunch of comments tomorrow. And I giggle at them all. But here we go. Let's go to Judge Frost. There is sound. I didn't mute it. Don't worry. See? Told ya.
Good afternoon. I'm sorry. Good morning. It's Judge Frost, and I have one person calling on a phone today. Are you by chance Miss Beekner?
Yes, I am.
You hear me okay today?
Yes.
All right. I'm going to put a name on you. Mr. Beekner, are you able to unmute?
There we go.
All right. Good morning, Mr. Beekner. Can you see and hear me okay?
Yes.
I'm going to call your case. This is 23 FA 1509, in re the marriage of Edward and Brooke Beekner. For the appearances today, I have both parties appearing separately. Mr. Beekner, and remind me, am I pronouncing that correctly?
Yes.
Mr. Beekner is by Zoom video. I can see and hear him, and I've confirmed he can see and hear me. Miss Beekner is calling in by phone today, and I've confirmed she can hear me. I can hear her as well. We're here we had touched base in February, and I heard from both of you, and then we set today for a stipulated divorce hearing. Mr. Beekner, are you wanting to proceed with that stipulated divorce or legal separation, I mean?
Yes.
Ms. Beekner, are you wanting to proceed with that?
Yes.
All right. And Ms. Beekner, based on the agreement that we had talked a bit about and that was previously filed, Is that the agreement you want to go forward on today and have me adopt?
Yes.
Mr. Beekner, for you as well?
Yes.
Okay, I'm going to put you both under oath, and then I'll ask each of you questions about your financial disclosures, the agreement, and some other questions to do with your divorce. At the end of it, if I am satisfied with all of your answers, I'll be able to grant you your judgment today. Could each of you please raise your right hand? And Ms. Beekner, I'll need you to tell me when it's up in the air.
It is up.
You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, Mr. Beekner?
Yes.
Ms. Beekner, how about you?
Yes.
All right, thank you. You can both put your hands down, and I will start today with Mr. Beekner. Also, for the record, I'm going to be marking as exhibits the agreement. It was filed as document 2 on September 8th, 2023. That'll be exhibit 1 today. Mr. Beekner's financial disclosure document 7 will be exhibit 2, and Ms. Beekner's financial disclosure document 10 will be exhibit 3. Have both of you reviewed those documents ahead of our hearing today so that you can talk about them?
Yes.
Ms. Beekner, I couldn't hear you.
Yes, I have.
All right, perfect. Mr. Beekner, could you start, please, by stating your name and your current address for me?
Edward Beekner at 4289 Dickey Lane, Madison, 53718.
Mr. Beekner, did you cooperate with Ms. Beekner to file a joint petition for divorce to start this lawsuit?
Yes.
Do you remember preparing that paperwork?
What's that?
Do you remember preparing that paperwork and filling in all the answers?
Yeah.
I see a signature with your name under it. Do you recall signing that document?
Yes.
Was everything you stated in your petition true and accurate to the best of your knowledge?
Yes.
For at least 30 days before filing for divorce, did you live in Dane County?
Yes.
For at least 6 months before filing, did you live in Wisconsin?
Yes.
Have you been on active duty with any branch of the military while this divorce was open?
No.
Have you been on any public benefits?
No.
And the two of you do share 3 children, correct?
Yes.
And they're all adults?
Yes.
Do you believe your marriage is broken, your marriage with Ms. Beekner?
Yes.
And what's the reason you're asking for a legal separation as opposed to a divorce today?
Because I'm on her health insurance, and if we go for a divorce, I lose the health benefits, the health insurance benefits.
Okay. And are you under any current health issues?
I'm type 2 diabetic.
Is that reasonably well treated right now?
Yeah, it's under control.
Do you understand? I just like to explain this. What you just explained is a legitimate reason for a legal separation. But I do want to advise you that under the law, after 1 year of legal separation, either party can ask the court to convert that into a judgment of divorce. And if I'm asked to do that, I have to do it. It's automatic.
I understand.
So I just want to make sure you understand, as long as Ms. Beekner is fine with it and you're fine with it, you could be legally separated for the rest of your lives. But if either of you changes your mind, you can convert it to a divorce and then you'll lose that health insurance either way. You understand that?
Yes, I do. I mean, we've both been acting as reasonable people during this whole situation.
Okay, well, I'm glad to hear that. Could you confirm for me your date of birth, please?
September 22nd, 1962.
And the date of marriage?
It was July 1st of 1989.
Thank you. And you are here without an attorney today. Did you understand that if you wanted to hire an attorney to represent you or advise you on this divorce, this legal separation, that you could do that?
Yes, we both decided that we would proceed with it this way to just simply to keep it uncomplicated and not enrich attorneys for no reason.
Sure. So that's a voluntary choice you're making to represent yourself?
Yes.
And you don't want additional time to go talk to a lawyer?
No.
Okay. Do you believe you're capable of representing yourself today?
Yes.
I ask a couple of questions so I can trust that unrepresented parties, that I can trust what you're telling me you're agreeing to today. The first one is, are you under the influence of anything like drugs, alcohol, prescription medication, or anything similar that would interfere with your understanding what you are agreeing to today?
No.
But he will be
Are you
later.
under any physical or mental conditions or impairments or disabilities of any sort that interfere with your ability to understand what's going on in court and what you're agreeing to?
No.
Let's talk a bit about your financial disclosure statement. Did you prepare that document that was filed with the court?
Yes.
When you completed that, was it a true and accurate statement of your income, expenses, assets, and debts?
Yes, at that time.
And other than account values go up and down and balances on debts go up and down, has anything else changed on that document?
No, it's not making as much money this year as I did last year.
So the number that was put on that document, was that, you filed it in January, was that based on 2023?
Yes.
So your income might be a little bit less this year?
It should be quite a bit less. That was an unusual year.
Last year was unusual?
Yeah, in order to pay down the house and so on, I took more money from the business because I own my own business to pay down debts and so on. Basically.
So I'm a little curious on the income part. You put a monthly income from salary or wages. So your business does pay you as an employee, correct?
Yeah, it's a corporation.
And is that amount probably still the same, the wage that you earn?
Roughly, yeah.
And then there's a bonus that is received. Is that where you were withdrawing more from the business?
That's where I was adding more.
And that, first of all, is that entirely within your control? Do you dictate how much you take out, or is there any other owner that weighs in on that?
I'm 100% owner of the corporation.
Okay. And what amount do you imagine you'll withdraw on average currently?
Being self-employed and small business owner, that varies from year to year, but I've seen it like 88,000 to 109 roughly. It varies depending on years and income.
But that's a reasonable range of where it might fall.
Yeah.
And that's again, just to be very clear for me, that 88 to 109,000 is the amount you withdraw as an owner in addition to the wages that you receive as an employee.
No, I'm paid as an employee, so that's total. So
interesting. So do you pay yourself bonuses like on a W-2, or do you withdraw money?
So this was something that I just did last year. So started doing last year. I paid the bonuses and just kept a straight payroll and paid some bonuses, and all on the paycheck being paid as an employee.
Okay. Okay. So somewhere between 88 and 109,000 is what you anticipate will be your total income this year.
Yeah, but like I said, every year is different. It's owning a business is not as a stable income.
For sure. You did put down rental income of 400 per month. Is that still something?
Just a second. You two pause it. Sorry about that.
No problem.
So what did you say again?
The rental income of 400 per month that you wrote down, is that still income you're receiving?
Yes.
And do you believe your expenses are still about the same as when you put this together? So you'd put about $7,788 a month.
I really put a guess at that. But I would say that it's probably roughly the same, other than the inflation,
Sure.
is,
Okay.
I'll noticed my costs on everything, especially my MG&E bill, going up quite a bit.
Sure. All right. And then you list 4 vehicles, all in your name?
Yes.
Avenue Shell, you put a value down for that. Can you tell me where you came up with that value?
It's off of the P&L statement that the accountant gives me.
Okay.
The business is sitting on rented land, so the business value is based off of inventory and so on. And part of why I was able to take bonuses last year was running inventory down and doing other things and running the checkbook down in order to get my house payment down and other things, set, because I don't have extra incomes anymore.
Okay. Under the securities section, you put some mutual funds and managed accounts. Are those still about the same? I mean, the values I'm sure have changed a bit, but
yeah,
you still have 2 different accounts.
Yeah, I put down what I had off of the last statement when I filled out the paperwork. I would imagine that they're roughly the same. It probably fluctuated some.
And you have no retirement accounts or pensions?
Well, those are retirement accounts. Or maybe I'm not understanding why you're.
Yeah, there's only a slight difference. So a retirement account is a 401k, an IRA, an employer plan or a government plan. If you just own stocks or mutual funds, if you just took money to an investment advisor or to,
Those are simple IRAs, and I think there's a Roth IRA that I have in there.
Okay, so it's a mix of different retirement tools.
What's that?
It's a mix of different retirement accounts.
Yeah, and all through Thrivent.
Okay. All right. And then the home, no major changes there on either the value or the liens against it?
No, there's no liens against it.
Well, a mortgage, correct?
Yeah, the mortgage, yes.
And then you didn't list any debts, so no credit cards, no other debts like that, no vehicle debts?
No, that's one of the reasons I did
be
everything
nice.
with the business and took the bonuses to make sure I paid everything I could down.
Okay. Ms. Beekner also prepared a financial statement. Did you review that prior to today?
Yes.
Do you believe she gave a complete and accurate disclosure of all of her income, expenses, assets, and debts?
I believe she did.
Do you have any questions or concerns in follow-up to her disclosure?
No, those are her disclosures, and so I guess I don't have.
Okay. And then there is the agreement, Exhibit 1, that you both filed with your divorce paperwork. Did the two of you cooperate to put that agreement together?
Yes, we spoke. She was the author of that, and then I just added a couple of details to like years of the vehicles and things like that. And then we both signed and notarized that.
Okay. And under this agreement, it awards you the house and any equity in it, correct?
Yes.
And it looks like there is quite a bit of equity, probably about maybe a little less than 400,000. Does that sound about right?
Yeah, I don't know what the market value of the house would be. I only made a guess and used Zillow, which probably could be way off.
And do you, off the top of your head, do you know the property tax assessed value?
No, not off the top of my head. I just paid the taxes just a couple months ago, and I know I paid, I think, 7,000 or something.
Okay. It also, under this agreement, awards you those retirement accounts in your name, and those are, according to your disclosure, worth about 630,000, give or take.
Yeah.
Were those accrued during the marriage?
Yes.
Okay. And then it awards you your business. And do you believe all your personal property has already been equally divided between the two of you?
Yeah, except for maybe small things around here that, you know, I'm getting to her. She didn't have room to take everything on, and making copies of videos and photos and stuff for her. As I said, we've both been acting like adults with this whole thing.
And you're comfortable that that won't be a problem going forward?
It shouldn't be, no.
Then it includes a line that says personal life insurance policies that you're each agreeing to update the beneficiaries to include all of your adult children. I just want to make clear, that's something I would only order by both of your agreement. I wouldn't make either of you keep insurance on adult kids unless you agreed to do that. Is that something you want to agree to do and make a court order?
Well, these are personal, so these are personal life insurance policies that have each other as beneficiaries, and we would be both of us updating so at time of death that our beneficiaries would be our children instead of each other.
I do understand that. I'm saying I would never make orders about who you make the beneficiary on your life insurance unless you agree to it. So the only time I might order it would be if you had minor children and you owed child support, or if there was a maintenance obligation. So if you put it in here and I adopt it as a court order, then it's saying going forward, unless Ms. Beekner agrees or you get a court order changing it, that you're going to keep your adult kids as the beneficiaries. So if you fall in love again and get married and want to change it to that person, if you did that, it would violate this order as written, is why I'm explaining that.
Okay. I guess I don't think that was our intention when we wrote it out.
Do you want me to strike that? And then it's just up to each of you what you do and who you name beneficiaries on there?
I would appreciate that, yes. I believe she would agree with that if you want to ask her.
Well, I'll ask her about all this, yeah.
Thanks for giving the judge permission.
Do you have any questions for me about the property division part of this?
No, I don't.
Are you asking for maintenance from Ms. Beekner, which is financial support after legal separation?
No, I'm not.
Are you in reasonably good health?
Yes.
And do you believe you'll be able to keep operating your business and working there and earning income?
I have every reason to believe so, yes.
Okay. Now, your property division is extremely unequal, where you take a far greater value of property out of the marriage. What are your reasons why you think that's appropriate?
Well, there, boy, I had, I still owe on the house, which I shouldn't at this point, as well as other things, and I guess I don't know how else to answer that.
Let me explain a little bit about the law. Tells me to look at it and start with the presumption you each leave with an equal value from your marriage. And you had a long marriage, so that is a starting point I would have to start with. And then I look at a bunch of reasons under the law if I'm going to do anything other than 50-50. Your agreement, and if you both agree, that's one thing I consider. But your agreement gives you hundreds of thousands of dollars more value, even after accounting for the debts, than Ms. Beekner leaves with. And I'm curious if there's a reason for that, why the two of you agreed to that and why you think that's appropriate.
Well, I'm still over the house, and like I said, I have a fluctuating business. And I'm trying to make it to retirement. And this legal separation and us parting ways was not something that I had ever expected to happen or wanted to happen. It was not of it. The choice was pretty much taken out of my hands as far as I'm concerned.
Okay. I might follow up later, but for now, I'm okay with that response. Ms. Beekner, do you have any questions you want to ask Mr. Beekner right now? Ms. Beekner, I couldn't hear if you responded.
I do not.
Okay, I'm going to turn to you then. Could you state your name and your current address, please?
Brooke Beekner, 927 Harrington Drive, apartment 210, Madison, Wisconsin, 53718.
Ms. Beekner, do you recall cooperating with Mr. Beekner to create a petition for legal separation?
I do.
And when you created that document, did you put true and accurate answers to the questions in there? Ms. Beekner?
Yes, I did.
Okay. Can you confirm your date of birth for me?
1966.
For at least 30 days before the divorce, did you live in Dane County?
Yes.
For at least 6 months prior to the divorce, did you live in Wisconsin?
Yes.
And can you confirm the date of marriage for me?
Is July 1st, 1989.
Do you believe that your marriage with Mr. Beekner is broken?
Yes.
And he had explained to me a reason to go with a legal separation instead of a divorce. Do you agree with his reasons?
The reporter didn't hear that answer. If you could repeat it, please.
Yes, I do.
And do you have any additions to make to the reasons he gave me?
I do not.
Do you believe your marriage with Mr. Beekner is broken?
Yes.
Are you currently pregnant?
I am not.
And do you agree with his testimony that all 3 of your children are adults now? Ma'am, I'm not getting your answers very clearly. I don't know if you're maybe speaking into a speakerphone or away from it.
Okay. Yes, I do.
Okay. And do you recall signing your joint petition for divorce? I mean, legal separation that was filed?
Yes.
Prior to the hearing today, you filed a financial disclosure. Have you reviewed that document recently?
Not recently, but I'm aware of it.
Do you feel comfortable that you remember it well enough you can testify about it today?
Yes.
You also are appearing today without a lawyer, correct?
Correct.
You understand what I explained, that if you wanted to have a lawyer and you were willing to pay for one, you could have one?
Yes.
You're choosing not to do that?
Correct.
And do you believe you're capable of representing yourself today?
Yes.
I am asking the same couple of questions so I can make sure I can trust you know what you're agreeing to today. Are you under the influence of anything like drugs, alcohol, prescription medication, or anything similar that would interfere with your understanding what you're agreeing to?
Not that would interfere what I am agreeing to, no.
How about any physical or mental impairments or disabilities? Are you under any that interfere with your ability to understand what's going on?
Be unable to understand what's going on.
We couldn't hear the beginning of your answer. Could you start over?
Sure. None that would make me unable to understand what is going on.
Okay. When you prepared your financial disclosure, did you give a true and accurate statement in there of all your income, expenses, assets, and debts?
Yes.
Is there anything major that we would need to update from that disclosure where you either have a new debt or new assets of significant value?
No.
You put down that you work for Nelnet. Do you still do that?
Yes.
And then you wrote down you have a second job. What's your second job?
I am a head cashier at Farm and Fleet.
Okay. How many hours a week do you work?
Well, I work 48 hours a week for Nelnet, and I work approximately 20 to 25 hours a week at Farm and Fleet.
Okay. And what's the reason behind having that many hours a week?
To pay my bills.
Okay. So necessity, essentially.
Yeah.
All right. Are your expenses about the same as when you prepared that document?
Yes, they are.
You listed 2 vehicles that you own. Is that accurate?
Yes, it is.
And you put down the only retirement or stock type account that you have is a federated 401k?
Correct.
And then you didn't list any real estate. So the real estate Mr. Buechner wrote is the only property the 2 of you owned?
Correct.
You did put a number of debts down. Are these credit cards all in just your name?
Yes.
Were they all created after the divorce or during the marriage?
Most of the credit cards were there during the marriage. The debt that has been occurred has been since the marriage.
So you had the credit cards, but they were paid off?
Right.
Okay. And now there's quite a bit on most of them. Is there a particular reason behind that?
When our daughter moved out of the house, she was unable to pay her bills. So I did quite a bit of help paying her bills.
Was that so that was after you guys separated and you filed for legal separation?
Yes.
Did you talk to Mr. Buechner about that choice to incur those expenses for your daughter? Ma'am, we're losing you again.
I did not.
Okay. All right. And do you think that it's fair that you be responsible for all those debts without any contribution from Mr. Buechner?
Well, I don't think it's fair, but it was a choice that I had made.
And did you ever ask him if he would contribute to any expenses for your daughter?
I did not. He had made it very clear when she had moved out that he was not going to be assisting her.
Okay. All right. Did you have a chance prior to today to review Mr. Buechner's financial disclosure? Ma'am, could you repeat that again?
I did.
Okay. And do you believe he made a complete and accurate disclosure of all his income, expenses, assets, and debts?
I believe so, yes.
Did you hear all of Mr. Buechner's testimony today?
I did.
So he explained quite a bit to me about his business income and how last year was an unusual year, and he explained the reasons why. Did you hear all of that?
Yes, I did.
Do you agree with his summary that during the marriage and historically he always had income around that 88 to 109,000 range?
Yes.
So that last year where it was more like 200,000, that does sound unusual to you?
That is unusual, yes.
Okay. And do you have any questions or concerns about that explanation?
No, I do not.
All right. Did you have any questions or concerns about any of the values he gave to his vehicles or his business or anything else?
No, I do not.
We couldn't hear you there, ma'am.
No, I do not.
The two of you also filed an agreement along with your petition for legal separation. Mr. Buechner said you typed that agreement up. Is that accurate?
The reporter didn't hear that answer. Can you repeat it, please?
That is correct.
All right. And why did you come up with that agreement? What was the thinking behind the terms you put in there?
Well, the separation of our marriage was basically my fault. And I didn't want him to lose the house when I knew that our sons were living with him. I had agreed.
Oh, you just broke up. If you could repeat that, please.
Sure. So I had agreed to separate myself from the ownership of the home.
So did you hear me explain to Mr. Buechner state law in Wisconsin about how I start with the presumption of a 50-50 division?
Yes.
Did you have any questions about what I explained about the law?
No.
And ma'am, you understand that the proposal you put together gives him essentially all of the value of the marriage, and the only value you leave with are your 2 cars and your retirement account, which are worth far less than anything you said to give to him.
Yeah, I understand that.
Ma'am, we couldn't hear you again.
Yes, I understand that.
Why would you propose to give up your right to so much value from this marriage?
Because of the circumstances behind our separation. It being my fault, my actions.
And ma'am, do you understand in Wisconsin, we're a no-fault divorce state, it's called. And I know you're asking for a legal separation, but it applies equally there, that I don't even consider whose fault it is that the two of your relationship ended. That's not part of what I put into my decision on anything. The only exception would be if one of you wasted significant marital assets, I can consider that. And that sometimes is also the reason the other person decides to separate from you.
And I had done that on a couple of occasions. I had racked up significant credit card debt that we had to then pay down. And so we lost out on paying down the mortgage more than we should have.
Okay. And what did you spend that money on?
Basically, our children.
Okay. So why is that wasteful?
Well, because the significant amount of debt.
How much are we talking?
Total about 40,000.
Okay. So the only reason you have why you think Mr. Buechner should have all of that retirement value over 600,000 and the equity in the house, which might be 300,000 to 400,000, is because you feel some guilt or that you're to blame for your relationship being over?
Yes, and I don't want him to have to uproot everybody because of my actions.
Your kids are adults though, right? They presumably will move on in the near future. We couldn't hear you, ma'am.
Presumably in the future, yes.
But if I adopt your proposal, that's permanent, meaning if your sons moved out tomorrow, you would still have that much less.
Correct.
And you're working 2 jobs and he works 1.
Yes.
Are you asking for maintenance from Mr. Buechner?
Maintenance.
We couldn't hear you.
I am not asking for maintenance.
And why not? Well, ma'am, why not?
Well, it's just going to go back to my guilt. You know, and the financial hardship I had put on the family a couple of times.
What were you buying for your kids? I'm not quite following why that was such a problem.
Little trips and, you know, kids need clothes and supplies. And
did you work during the marriage?
I did.
Throughout the entirety of the marriage?
Of the marriage, yes.
Were you not contributing to retirement that whole time that yours is fairly small?
That is correct.
When did you start contributing?
Contributing about 10 years ago.
The reporter didn't hear the beginning of your sentence.
I started contributing about 10 years ago.
Thank you.
All right. And did both you and Mr. Buechner put your incomes toward the family, including all the bills and the kids' expenses and things like that?
Yes.
Did you have joint accounts during the marriage?
Yes.
Okay. And I assume he has a lot of money in a couple of retirement options. Was there a decision that his income was going to go or that maybe family income was going to go into his retirement accounts?
We really never even had that conversation.
Okay. Was there a conversation as to why you were not contributing to your retirement for more than the last 10 years?
No, there really wasn't.
Okay. I'm going to be honest. At this point, Ms. Beekner, from what you've told me, I'm not hearing anything that would convince me to adopt an agreement that's so unfair as this one. You've mentioned vaguely about guilt for things, but spending money on your kids at times isn't enough for me to overcome this. I don't know what your other guilt is, and you don't have to share it because this is a no-fault state, so I don't need to hear about it. I mean, maybe it would convince me, but if I doubt that it would change my mind on this. So unless you want to explain more to try to convince me to agree that your agreement is fair, I'm going to reject your agreement, and we're going to have to keep trying on this. Is there any?
Well, I did do a lot of spending in clothes and shoes as well, besides just the kids, but.
Throughout the marriage or just at the end?
Throughout the marriage.
Okay. All right. That doesn't change my mind at all. So I'm not going to adopt the agreement that the two of you have put together. It's grossly unfair to Ms. Beekner, and I haven't heard any reason that would satisfy me that that's fair or appropriate under your circumstances. The two of you were married for 34 years. You built this wealth together, even if it came out of Mr. Beekner's income more than Ms. Beekner's. It's a marital property state, so all of that was actually both of your incomes, both of your assets, and both of yours to share later in life or at divorce. And I haven't heard anything that would explain to me why I should give 90% of it to Mr. Beekner and 10% to Ms. Beekner and leave her in financial straits working 2 jobs and not being able to support herself, but to let Mr. Beekner have all the value and his normal employment. So I'm rejecting your agreement. That doesn't mean you can't modify it into something that I would later accept. But for right now, you're going to either have to try agreeing to something else that's more fair, or, and I may need to hear some more reasons why you would not get maintenance, Ms. Beekner. Or we're going to have to get to a contested divorce where I'll just have to ask questions of both of you and then decide what's fair, even though it's different than what you're both asking me to do today. So do you want some time to try talking with each other and try to reach a different agreement, or should I just set a divorce and I'll hear from both of you at a trial and decide everything?
Do a trial, please.
Ms. Beekner?
Well, we can try talking to each other about it.
Okay, Mr. Beekner, are you okay with making another effort now that you've heard from me today?
I guess that's the only choice that we've been left.
Well, the other choice is that we go to a trial and I just decide what the law says is fair and appropriate.
What do you suggest that we do to convince you of what we're trying to do here?
You can't.
So I think I've given you the full explanation I have, which is I haven't heard any reason under the law why something other than a 50-50 or nearly 50-50 division would be appropriate for a marriage like the two of you had. You're welcome to look at the statute and try to see if there are reasons you forgot to tell me about today that would show why it's fair and appropriate, or if you came back with an agreement that was closer to equal. It doesn't have to be equal, but at least closer than this very, very unequal division. That might be enough where I felt comfortable. And then I would need to hear a little bit more about why it's appropriate for her to work 2 jobs to earn way less than you do, and not to give her any maintenance to try to help her get through to a retirement date or something else. And I'll explain. Part of my job, the law tells me I have to review with the law in mind what you've agreed to. And if it's unfair and it's likely to leave one person as essentially a burden on the state, I have to reject it. And frankly, I do think your agreement has a high likelihood of leaving Ms. Beekner a burden on the state, because the two of you have a lot of money, but she's getting none of it or very little of it. She's very close to a retirement age and has almost no retirement assets, even though there's a good amount in the marriage. She has no home, and her income is good, but that's with two jobs, and it's not so good that I feel like she'll be able to build up her own retirement in the next few years. So, in other words, she very soon may be somebody who the state has to pay for, even though there were marital assets that would have helped her if she loses a job, if her health goes down, or if she just realizes I can't work two jobs forever. So that's my explanation. I can't give you any more insight than that. What we're going to do is we're going to put another date on the calendar. We'll call it a status. If you have a new agreement and you put it in writing and file it, I'll ask you each questions about it. And if it resolves my concerns, then I'll grant you your judgment at that day and time. And if not, we'll talk about scheduling a trial. So I'll give you a few weeks to try to talk to each other and see if you have any other ideas of an agreement. Ashley, when could we put them back on?
How long do you want to give? 30 days?
Anywhere between 3 weeks and 30 days.
And 30 minutes?
Yeah.
We could do Thursday, May 16th at 2 o'clock.
Mr. Beekner, can you make that work?
When was that again?
Thursday, May 16th at 2 o'clock.
Yeah, I can do that.
Ms. Beekner, can you?
Yes, I can.
All right, we'll send out a notice with the hearing details. It'll be by Zoom again, so you can call in or log on to Zoom, whatever you prefer. I'll see both of you in May, and I hope you both have a good rest of your day.
Thank you.
You're welcome.
All right. I'm not going to get into the debate going on in chat, except to say, okay, maybe I am. Who knows? Sounds like, it really sounds like, everything points to she raised the kids, she worked, maybe she doesn't own a business, but she worked, but he couldn't have made his business what it was without her doing what she did at home. He just couldn't. I know because I'm a single mom and nobody can change my mind on that. There's not enough time in the day to, for him to build his business and raise his kids. And it sounds like, thank freaking God she's the one that raised the kids. Just sounds to me like. And they were married so long that yes, everything is 50-50. It is. That's why you get married. That judge, man, he is amazing. He is amazing. He stepped in. He's not allowed to give legal advice or anything, but he's allowed to say no, absolutely not. And I don't know. Yeah, she bought clothes and shoes. Come on, he's making $80,000. If my husband was making $80,000 a year, I would buy shoes. I would buy shoes. Let me tell you, I'd buy shoes. I love shoes. And just listen to what he was saying. He makes a lot more than what he said. He makes a lot more than what he says. Yes, being a business owner, money goes up and down. We all know that. But he's doing fine. He has other sources of income, he rents out. I don't know. I'm just so glad Judge Frost did that. I'm just so glad. I'm just so happy. I cheered when I heard it. But I'm thinking about right now of everything I've built in my life. If I would get married now, um, no, he wouldn't deserve it. I don't think he would deserve it. But if I was still with my original husband and we got divorced, yeah, I mean, yeah, he would deserve it. 80K is a lot. Hell yeah, that's a lot. That's two incomes. That's two paychecks. Okay, if she worked up loads of credit card debt, if she worked it up for stuff for her, maybe. I mean, and I'm going out maybe. I'm not even saying yes. But he didn't disagree when she said this is for the kids. Most likely it was things that he didn't agree they needed. You know, like back in the 80s, my sister wanted a pair of parachute pants so bad. They were $80. And that was a lot back then. And my mom bought them for my sister because she just wanted them so bad. And my dad was pissed. So maybe something like that. But even, I mean, that's not enough to convince me. They're her kids. They're her children. And no, it wasn't his money. It's not his money. It's marital money. They're married. All right. I'm going to get off my soapbox because these are, maybe I should play the person getting arrested again for the third time this stream. Just kidding, I won't. Just kidding, I won't. Just kidding. I did get the judge from Kenya. No, what? Wait, where did you guys say it was? Not Kenya. Somebody type it in chat real quick. Nigeria? Nigeria, I think. But I didn't have time. Go put your purple parachute pants on. Yes. Thanks, Cloud. You think he's from Jamaica? Do you really? I was I was sure it was in Africa somewhere. His accent sounds, I don't know. I don't know. I just love his accent. I love it. Reb, thanks for popping in. No, no, I don't ever sleep because courts are about to open, so now I have to get to work. And I'm about to throw all these animals out of my house. Get outside and play. Don't come back in until the streetlights come on. Hi, Maggie. Thanks, Ja. All right, guys. Have a good day. I will talk to you again tomorrow, and I might put the if I can, I might put up first the trial with Fleischer, even though he didn't post the verdict, so we don't hear him speaking. So he didn't post the verdict. We don't hear him give the verdict, which would have been the best part. I'm just going to put it up. If you guys want to watch it, you can. And then I'm going to put more on the Patreon the next couple hours of the Australian court. All right, guys. Yeah, they were saying Jamaica in chat. Not Nigeria. They were saying Jamaica in chat. I don't know where he's from. All right, guys. Hi, Tinsel. Now, goodbye, everybody. Have a good day. Behave.